on to the next issue, because I've only got 10 more minutes. So those subpoenas that you issued with respect to the 10 members, they're no good now.
That's correct.
You have to reinvigorate those. So, Dan, I wonder myself if they weren't there.
Well, that's the whole issue with this, Your Honor, is that from what I know, from what the police are relying on and the Crown is relying on, the bulk of the disclosure material, what little I've received, the bulk of the material consists of incidents that happened 4 years ago, 3 years ago, up until a month before my arrest. So all this material that's the bulk of the Crown's disclosure has absolutely nothing to do with this matter that I was arrested for on July 25th, 2018. And if that's the case that the Crown is going to put forward, then I'm going to have to answer full defense. And I'm going to have to rely on the police, the related material police members that are detailed in the bulk of the disclosure.
All right. So, interesting, Mr. Barber.
Yes.
And that's exactly why I'm being criminally prosecuted. Not because I broke the law on July 25th, 2018. No, here's the real reason. This is the West Shore RCMP's report to the Crown prosecutors in recommending charges. And it says here, the safety concerns of the members and staff of the West Shore detachment are very much in mind when an unauthorized person is in or around the detachment with no reasonable explanation. Officers have used their discretion in the past when dealing with the public who were cooperative and not aware of what they were doing. This incident with Dan was different. Given the totality of the circumstances and the historical behaviors displayed by Dan, police are recommending 3 charges. And you'll see here, count 1 is mischief, count 2 is obstruction, and count 3 is a peace bond, which is a restraining order. I was intrigued when I read this because I don't know how they determine who's an unauthorized person to be around or in a detachment. I've seen press reports in the past of people protesting there in large groups and being loud and angry and So I guess those are authorized persons. Those are okay. And I read something interesting that in this, they say that the officers have used their discretion in the past when dealing with the public who are cooperative and not aware of what they're doing. And basically what they're talking about is they had to tell me about, people who were trying to climb up the building and had weapons on them and were trying to potentially break into the staff cars that were there and had homemade weapons on them and drug paraphernalia and people that were trying to gain access through the main entrance after it was closed and locked and were doing so in a very inappropriate manner. So they're saying that those people cooperated and gave their ID. But I didn't cooperate and I didn't give my ID, and that's why I was arrested, because I didn't cooperate and give my ID. That's what they say. Which is funny because those people that did cooperate and did give their ID, well, they were actually doing something wrong. They were actually on the property. They were actually doing something and had items on them that they weren't allowed to have. Actually. But I wasn't actually on their property and I didn't actually have any weapons or any drug paraphernalia or anything like that. And I found it really interesting how they write this report to the prosecutors saying that I was an unauthorized person in or around the detachment with no reasonable explanation. How is it that I gave them notice about what I was doing, why, what it was for, and a bunch of other information that I didn't have to give them, but I gave it to them up front, and then they come out and ask me what I'm doing. And I tried to explain what I was doing. And as you remember, the watch commander, the terrorism expert, he kept asking me. And I kept trying to tell him what I was doing. But he kept interrupting me and saying, we're not going to have this conversation. So how can they write this to the prosecutor, that I'm an unauthorized person in and around the detachment with no reasonable explanation? And how can they prosecute me for my historical behaviors? How can they do it? Well, you're about to find out. Welcome to part 15. Here we go.
I take it that's all for context, correct?
It's for context, and again, he may want to seek some legal advice about that. I'm not going to get in the way of him subpoenaing people, but whether that's going to be helpful...
The court is not going to let you run down each and every one of those. It's just not.
So...
We're not going to have a mini trial.
Right. I won't be...
It's just not going to happen.
No, I won't be answering full defense. So I bet you thought you had the right to defend yourself in a criminal trial, hey? Well, it's not going to happen. It's just not going to happen. And this thing that I keep saying here, answer full defense, I'm saying it slightly wrong. It's actually full answer and defense, not answering full defense. This wasn't something that I'd actually thought I'd have to bring up. So, if I considered that it would have been, I would have dusted up on my reading a little before this hearing. But basically what that means, full answer and defense, actually comes from Section 7 of the Canadian Charter of Rights and Freedoms, which says the following: right to make full answer and defense. Anyone accused of a criminal charge has the right to know the case against them and put forward a defense. In addition to being a principle of fundamental justice, this right is also protected by the right to a fair trial under Section 11D of the Charter. Quote, full answer and defense, unquote, encompasses a number of things, including the right to counsel, the right to examine witnesses, which is what I'm trying to do, and most importantly, the right to full disclosure by the Crown. Right, so when a prosecutor wants to bring in a bunch of stories from the past, from people's imagination that were fabricated, and tell the judge this, well, guess what? I don't have a right to make full answer and defense.
Well, I don't.
I understand.
Know about that. All I am telling you is that as a matter of procedure in the court, it is not going to then, even though some things are in for context, it is not going to let you litigate each and every one of those instances through those officers. It isn't. Okay?
I can't answer full defense. When I first read this transcript, I was actually quite surprised that they transcribed what I just said correctly, where I say, I can't answer full defense. Because I was expecting them to transcribe it with a question mark at the end, because that's what you would assume I would say. I would be asking a question. I can't answer full defense? But I'm not asking a question. I'm actually telling the judge, I can't answer full defense. I'm telling the judge this. I'm telling the judge how corrupt and unfair the whole system is. And I'm telling her, I can't answer full defense. I'm not asking her. I'm telling her.
It's not going to happen.
Okay, perfect. So I'm not...
I know you keep saying it's not full answer and defense. We don't agree on that, all right? So often things go in as context and we don't track those down. We don't run those through.
Okay.
But in any event...
So I won't be able to...
Well, I think there's a good idea about you speaking to legal counsel, because I don't think you quite understand.
Well, the legal... What I was actually trying to say is the legal advice, it's actually Mr. Barber that needs the legal advice here.
It doesn't even necessarily go in for its truth, which is why the Crown isn't, which is why the court's not going to run it through, okay?
Well, as I said, Your Honor...
It's you don't get days and days of court time.
No, I don't want days and days of court time.
Yes. Well, you're not going to get them.
This is so funny. I don't want days and days of court time, but the judge is telling me you're not going to get them. You're not going to get them. And it's funny because if you've ever followed like a major court case, like the media is covering or whatever, sometimes like a lawyer or a prosecutor, just to make like submissions, like suggestions for like sentencing, just sentencing alone, that can be like a day or like 3 days in like a very serious matter. So, and that's not even like a trial. That's just like, Your Honor, I suggest that sentencing be this based on this. And that can take a day or 3 days. But me, I won't get days and days. Even though I don't want them, I'm not getting them. We could have this finished in under a day if the Crown is restricted.
Oh, you've only got a day.
Okay.
So that's something we need to discuss as well, Your Honor.
Don't bother asking me how long the defense is going to be, I guess.
Well, the time's already been set, so presumably somebody's gone through this with you.
That's the Crown's case.
So
no one's
when
asked
this was
me.
set for.
No one's asked me how long the defense...
No one's ever asked you what your time estimate is?
No, never.
Never. Okay.
So,
this is
Your
all,
Honor, if
this
I could shed some light on that...
This has all been set to Mr. Barber's schedule.
Okay.
Mr. Barber, in December, Mr. Barber said he's not back till September 9th, 2019. So I waited 9 months for Mr. Barber to come back on September 9th, 2019. Ironically, today is September 5th, 2019, so thanks for...
But he's here by phone.
Thanks for coming back early, Mr. Barber.
I don't know what any of that is about, Your Honor.
Well, that's what you told the Justice of the Peace and the JCM here.
Okay.
So thanks for coming back early, Mr. Barber.
Not correct.
So can we just go back to... Can we just go back? So is all of this other material, is somebody going to be walking through that? All of these other instances?
Are you speaking to me, Your Honor?
Yes, I'm talking to you, Mr. Barber, yes.
I had no intention of getting into any of the details of any of the other incidents, but for a very general overview for context purposes.
And is that going to...
Nor would I.
Is that going to state of mind rather than anything else?
Right. State of mind and I.
Right. So not in for the truth of its contents, right?
No.
Yes.
Nor would I be allowed to do that. I don't think.
Now, this is pretty interesting how the prosecutor is trying to get my historical behaviors in on this trial before a trial judge by saying that, well, it's a state of mind. The police knew who he was and they knew he's got these historical behaviors, which is funny. How can he rely on that when the police readily admit that they had no idea who I was? It wasn't until they arrested me and held me in custody until I ID'd myself that they found out who I was. Then it was state of mind after they read a bunch of imagined stories about me that scared police officers have made. It's been documented.
You would not be.
Now, Mr.
And you'll be limited even in terms of what you get in that regard, you know.
Sure.
I mean, if it goes to character, for example, right?
Sure. No.
It would only go in for state of mind. It's not going in
Yes.
for the truth of it, right? So that's an important distinction.
Now, if Dan opens the door, it's a completely different thing. So that's why I say he should get legal advice. But, Your Honor, as far as the scheduling, we have a day set.
Yes.
And that day was set in order to address basically the Crown's case. That's correct what Dan says, and what the intention was, I think, was if Dan still wants to subpoena 10 or a dozen officers, that a different day should be set for that, so that those officers aren't just sitting around all day waiting to get on the stand or not. Now, by way of background, this has nothing to do with proving our allegations. This has happened before with Dan, as I understand it, where this exact same sort of pattern happened. A number of witnesses were subpoenaed and never called to the stand.
What date was that?
So.
What date was that? What matter was that?
So what I'd like to do.
What date was that? What matter was that?
Your Honor, is get a second.
Never happened.
So,
yeah, that's never happened. And Nicholas Barber of Nanaimo Crown Council just fabricated that all on his own. Here he is, misleading yet another judge to try to get a win. An easy win against a self-represented accused who didn't even commit a crime. This is the role of the prosecutor.
Get a second day that then Dan could organize his defense and have those witnesses for that date, and then we would have that on and of its own. We will see what happens on the first day, and whether the trial judge will allow and how much they will allow Dan to get into all of these kinds of things, in sort of a step-by-step way.
So that makes some sense to me, all right? I'm surprised it's going to take the Crown 5 hours to get its case in, but what?
Well, that's with cross-examination, right, by Dan, and I don't know.
But Mr. Barber's suggestion makes good sense to me in the sense that, like I say, you know, these other things that go in for context, not for the truth of their contents, you know. That's evidence that, and it can only go in so far, all right? They, you know, they can't take issue. They can't raise issues of character and things like that, right? It can't be prejudicial to you. It's got to be strictly so that the court understands or the trial judge understands, you know, why this charge has been proceeded with. And so it makes good sense for the trial judge, then, to speak to you at the end of that evidence and you guys decide, okay, do you really want those other people or, I mean, presumably your arguments are kind of a free speech argument or something like that. Presumably, right? But, and so then? So I like that idea, and I think I will send you off to get another to just sort of reserve another day in the event that you need it, right? But you might not. You might not. You might just decide, nah, I'm going to go with what's here and I'm going to make my pitch, right?
I
Sure.
prefer not to go that route, Your Honor.
But I'll send, but just out of an abundance of caution, I'll send you to the JCM to get one more day. That's a reserve, after the March date in 2020, and if you don't need it, no problem. We fill these days up anyway. I mean, the court's busy, right? So we fill the days up.
I understand. My biggest issue with that, Your Honor, is that what happened in the past has nothing to do with the day of my arrest.
No, and that's something that you can argue.
Well,
but I mean, the trial judge is to be the decider.
Yeah, but
of that. Okay?
The problem with that is what they're bringing up isn't true, and I can prove it. So if they bring it up and I'm not...
Well, that's something you take up with the trial judge.
Yeah.
Okay?
Yes, Your Honor. The police have been lying about me for years. About incidents that I video recorded and contradict their statements.
I don't know what the evidence is going to look like, okay?
Okay. Appreciate it.
I really don't. So you take that up with the trial judge in this, so I will send you to the JCM to get one more day after that March date and then the trial judge can make a determination, after having heard submissions,
Sure,
as to where we go after that.
And just...
So that leaves the last issue, and I've got a couple of minutes to deal with that
And yes, I've only got a couple of minutes to insult your clothes, make fun of your clothes, and grill your friend for possibly recording, etc. Only got a couple minutes.
That the officer who's been transferred to Toronto or to Ontario, pardon me, can testify by video, and what's your view on that?
Now, I thought this would be a great opportunity to lock in the terrorism expert watch commander that arrested me, Arun Kundu-Thomsen, because not only has he been transferred to Ontario, but they're also trying to make it so that I can't subpoena police officers for the first day of trial. And that's one of the things I've done here is I've subpoenaed Arun Kundu-Thomsen as my witness for the first day of trial. And the reason why I do this is because in a lot of false arrest case, the police just don't show up and then it all gets dropped. Well, if the courts let you subpoena witnesses, you can subpoena the police as your own witnesses for the first day of trial. That way, there's no escape. That way, they have to show up and testify. And if they don't, well, you tell the judge, hey, here's my subpoena. So, Your Honor, would you mind putting out a warrant for their arrest for not showing up for court after being properly subpoenaed? Thanks very much. So, with that all being sabotaged by the court, I thought, as I said, this would be a good opportunity to lock him in. So, I'm trying to make it clear that he's the most important witness. I'm trying to get this all on the record. So my goal here is to just get him locked in. I'm not too thrilled about him testifying via video from Ontario, but I'm going to have to come up with something and make an issue of that down the road. But for now, my main goal is to lock him in because I'm assuming at this point that what they're eventually going to do is they're just going to say, well, he's not available to testify, so he's not going to be part of the trial. So at least this way, I get him locked in. Because that's, to me, right now, at this point in the proceeding, that is the most important part, is that he shows up and he testifies and I get to cross-examine him and ask him questions. So I'm going to go ahead and lock him in. Corporal Kundu-Thomsen is actually the most important witness for the Crown.
But that does happen, yes.
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 So as long as he's able to testify, as long as I'm able to cross-examine him, if it's...
Yes.
I don't take any issues with that.
Absolutely. And it happens all the time, right?
That's fine.
And actually, I can tell you my experiences when they're on video. You get a good look at them and you're not particularly inhibited. So that order that officer testify by video, that's going by consent, Mr. Barber.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. And so you're going to get your disclosure?
Thank you.
And I'm going to send you off to get that day so then we can essentially table the issue about your other subpoenas. It gives you lots of time and also it's to your advantage, because you can sort of get the sense of what the case is and whether you need to go that way or whether you want to take another approach. Done.
I certainly hope not.
Okay. So what's the next appearance date on this one?
It is the trial date, Your Honor.
Oh, that's it. Okay.
I think a confirmed trial date, or whatever we are calling them
March 3rd
now,
of 2020?
trial, might be a good idea.
Do you want to do that, Dan, today or?
That would be great. Yes.
You don't think you'll need another pre-trial? Let's confirm the trial date. If somebody else needs something, you can always come back, okay?
Thank you.
So I'll confirm the trial date today, then, okay?
Well, Your Honor, I'm sorry, I've misspoken. I think another date would be a good idea because I don't want to belabor this, the difficulty with getting the disclosure to Dan. It's only been able to get to him when a police officer served it on him at the courthouse, and so I foresee, once we get the data from his devices, Yet another delay and problem in getting it to him. He's refused it at his door.
That's not true, Your Honor. That's not true. He's lying.
So let's.
He's lying.
Okay. Why don't?
That's not true.
Why don't we tie down?
That's not true.
I don't lie.
Okay, why don't we?
He's lying. Liar, 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 liar. Let's review, shall we? The difficulty with getting disclosure to Dan. Well, he hasn't provided me with any disclosure. We're actually talking about getting that disclosure to Dan right now. It's been 11 months. Dan sent 4 letters. Where the heck is it? You haven't even responded to 3 of the 4 letters. Quote, it's only been able to get to him when a police officer served it on him at the courthouse, unquote. Now here's a very well-crafted lie. You remember in part 13 when I had a hearing in front of Judge Christine Lowe on August 15th, 2019? And I showed up to court telling that judge that I hadn't received a response for my disclosure. And the prosecutor, Nicholas Barber, told that judge that he had responded and that he tried to send it by registered mail. And I refused it. I refused to sign for it. And the RCMP brought it to my home. And I refused to answer my door. You remember that disclosure, right? The disclosure that I called the RCMP about right after I got out of that hearing and asked them, where the hell is this disclosure? And then I drove 20 minutes home. And when I got home, I had a phone call conversation with Corporal Christovel. He said he was only at my residence yesterday and he didn't believe I was home. And then I had agreed to drive 20 minutes all the way back out to where the West Shore courthouse is to get that, quote, disclosure, unquote, which turned out to be a wild goose chase. It was just 7 pages or 9 pages, something of just repeat material that I had already received. So that is what he's telling this judge, is that the only time the RCMP have been able to get this disclosure to me is when they had to serve it on me when I had a court appearance. Yeah, you remember that time that I had to call them and ask them where the hell is it? And then they called me when I got home and I had to drive 20 minutes back just to get it? Yeah, that was me being served when I had a court appearance. Oddly enough, when I showed up to court for that day on August 15, 2009, the RCMP and that disclosure was nowhere to be found. I had to call to get it and then drive back out there 20 minutes to get it. And I had to arrange all this all on my own.
Why don't we tie down the delivery of disclosure now? Where would you?
I've already worked it.
Where would you? Where would you accept disclosure?
I've already worked it out with the RCMP.
Okay. What is it?
They completely contradicted what Mr. Barber told the court.
I just need to know. What is the delivery?
Well,
How will you get service of this?
They're going to call me.
Okay.
I work 10 hours a day and I'm away from home 12 hours Monday to Friday. So Mr. Barber suggesting that I refuse to accept this material, that's not consistent with normal human behavior.
I don't have to know about that.
I'm just saying he's lying.
Yes. Okay. Fair enough.
It's pretty funny. This judge, not only does she not care that the prosecutor's lying, she knows he's lied. Like, who cares if he's lying? So what? That's what prosecutors do. Yeah.
But can I just?
I've already worked it out with the RCMP. They know what to do.
Well, no. I mean.
Well, I'd like it on the record, please, Your Honor.
Am I needed more specific? Yes, I do. I do need it to be.
So
what is your understanding of the service?
My understanding, according to Corporal Christovel, is that they will call me at my home phone number, which they've had all along. And that I will return their call because I'm away from home 10 hours a day, Monday to Friday, and I will meet them wherever they would like to meet, preferably at the courthouse, so I don't have to go to the West Shore RCMP detachment where I don't feel safe. And I will drive out from Victoria, where I live, to meet them on the date and time which we arrange ourselves. So here I've decided to cut this part out because the judge, who has only a couple of minutes for this, even though she had time to make fun of my clothes and grill my friend about possibly recording, she's now going on a fishing expedition about my personal life and wants to know some very personal things. So I'm just going to cut this part out and I'll come back to where she's done with her fishing expedition. But West Shore RCMP only made one attempt at my address, according to Corporal Christovel.
Okay. So as I understand it, Mr. Barber, the plan is that Corporal Bell will connect with Mr.
Oh, Dovell.
Okay. Dan by phone, advise that the disclosure is ready. I'll say this, done. You can expect a call well before October the 3rd, but no later than October the 3rd.
Okay, you guys heard it. I can expect a call well before October 3rd, 2019. But no later than October 3rd, 2019. Okay.
And I expect disclosure to be in your possession before October the 3rd. And if for some reason you've delayed that, I'll know that.
Okay. And the judge expects the disclosure to be in my possession before October 3rd. And for some reason, if I've delayed that, she'll know it. And I'm like, okay, like your intimidation attempt has completely failed. I can't wait to expose you all.
All right. So there's no reason to delay that. You're anxious to get that material.
For 11 months now.
Okay.
Actually, no, not anxious. Eagerly anticipating.
So, Mr. Barber, as I say, the plan is that the police will call Dan. Dan would then agree with police on a date and time to pick up disclosure. Presumably, it's going to be on the weekend. That means it won't be at the courthouse. You understand that, right?
Well, it could be in the parking lot.
Okay. Well, wherever you decide. I don't think at this point it really matters.
No, it doesn't.
And disclosure will then be given over to Dan, and those individuals will confirm that, presumably. Now, and no doubt somebody will be videotaping something.
No doubt. And now she's only got a couple of minutes to make a pot shot about someone's going to be recording.
So, okay. So, and as I say, that will be done on or before October the 3rd. I expect it to be done, and I expect there to be no issues with respect to that, okay? There's no point doing anything like that on either side, okay? And then we're going to confirm the trial date, okay, Mr. Barber?
Yes, Your Honor.
And we've tabled the issue. I'm sending Dan and yourself off to get one extra day and, after the trial date if, in the event that it's necessary, okay? And then the issue of whether or not those subpoenas will go will be decided by the trial judge, okay? And I think everybody's ready to go.
Yes.
Should be good.
Good. Thank you, Your Honor.
Okay. All right. Thanks, Don. Thank you, Mr. Barber.
Thank you, Judge Mrodzynski. Have a good day. Well, that's how that went. Thanks for your patience, everyone. This took forever to put together, part 14 and this part 15. And thankfully, there's no more lengthy hearings to transcribe. That is, of course, up until when the trial starts. And yes, this did go to trial. You guys are going to see the trial. But that's still a little ways away. There's some stuff that happens before the trial that you guys are not going to believe. And if I just told you what happened, you wouldn't believe me, and you have to see it to believe it. So stay tuned for part 16. It's coming sometime in April 2021. Thanks for watching.